Hey class, it's Mr. Stewart, and I am back from my conference trip to Florida, so we'll try to get back on track here in the course here with week 6. A couple things before I get into the material for week 6, or what I want to talk about in regard to the material for week 6, is the fact that you'll see that since I've been gone, I'm a little bit behind in the courses. I will be getting in there this week, and I will be responding in discussion boards, and I will be getting more grading done. I may not get caught up with grading this week, but I will try to get caught up by next week for sure. I've got 3 online classes this term, so it's a bit of a chore. Not complaining, but just when you do get behind, it takes a little bit to get caught up. I think. Some of you, maybe you've been behind in a course or something before, so you understand that philosophy. So hopefully all of you were able to take the first exam. We will have the second exam at or around week 10, so here in about a month we'll have another exam. Understand that there may have been a question or two that raised a little bit of a concern. One of the things that I always do with tests, if students complain about a particular question, I'll go look at that, see how many people missed that particular question, and then if the majority of the class missed it, then I will give the class credit for that and just chalk it up as a bad question. Now understand, I didn't write these questions. These were a standardized test question from the publisher for the textbook. So with that being said, I'm all about giving you the benefit of the doubt. So I will go back within the next couple weeks and look at a couple of those questions that some people had some issues with, and if necessary, I will give you credit for those where credit is due. So no worries about that. If you have not taken exam 1, I would highly suggest getting there and getting that done as soon as possible, because at some point it will close, and it will close prior to the next exam. So once we have completed exam 2, once it's open, you will not have the opportunity to take exam 1 again. So if you have not taken first exam, please get in there and take that first exam. Okay, today we're going to talk about chapter 6. And chapter 6 is very similar to chapter 5. Chapter 5 talked about lawyers. We did not have a integrity video for chapter 5. And that was for a couple reasons. One is I really didn't think it was necessary because the chapter was pretty straightforward. And number 2, it was a short week for me because I was leaving for Florida and heading to a conference, so I just didn't have time to get one done, even if it were necessary. Chapter 6, in regard to judges, is a little bit more difficult to comprehend because judges are a bit more complex than simply being an attorney and officer of the court. Because understand that judges have a very specific role, and depending upon the type of case, whether it's criminal, whether it's civil, whether it is a trial or a hearing, or the type of trial that's being had, judges' roles may change just a little bit. As a general rule, we understand that the role of the attorney is to advocate for their client. And if you're the prosecuting attorney, you're advocating for the people of the state or the victim in the case. If you are the defense attorney, you're advocating for the defendant. And it's not that we're trying to get the defendant off, but it's based on the fact that our Constitution allows for an adequate defense. If you're charged with a criminal act, the prosecution has the burden of proof, and therefore every single person charged with a crime has the right to an adequate defense. And so it's just fair. That's really the only way I can explain our justice system, is that it's fair, as opposed to many other countries' justice systems are very one-sided against the defendant, and we would not consider them to be fair. Whereas with judges, again, it's a little bit more complex. And I'm not going to go into everything that this chapter goes into. One of the things I want to talk about is some of the duties of a judge, and I want you to understand what these duties are. Judges typically are not the decider of fact in a case. That's the jury's job if a jury exists. Now we're talking about criminal trial courts or civil trial courts. and mainly since this is a criminal justice class, we're talking about criminal trial courts. When somebody goes to trial, it's not up to the judge to determine guilt or non-guilt. Understand, we do not determine innocence in the United States. The burden of proof is on the prosecution. They either proved you were guilty or they couldn't. If they could not prove beyond a reasonable doubt that you were guilty, we don't find you innocent. We just find you not guilty. There is a difference. You know, just because a jury finds you not guilty doesn't mean they think you're innocent. It just means there was not enough evidence to convict you to the standard of proof that the law requires. I just want you to understand that. Now, also understand that a not guilty verdict carries the same connotation as being innocent, because once you're found not guilty, prosecution stops. You know, case is over. Decision has been made, and double jeopardy attaches at that point, and so you cannot be tried for that same offense again in that same court. Only in very rare occasions will a judge actually be a decider of fact, and that is if the client, the defendant himself, decides that he does not want a jury trial, that he would like the judge to be the decider of fact. And in my opinion, that's a pretty bad decision on behalf of the defendant for several reasons. The first one is juries must find you guilty unanimously. That means you must have, depending upon the state, 8 to 12 people must unanimously agree that you're guilty before you're found guilty. If they cannot unanimously agree, then either they cannot reach a verdict, or you would be acquitted. So with that being said, it's a lot harder to get 8 to 12 people to agree on one thing than it is to get one person to agree on one thing. And also, juries do not have a formal legal education. They are really a neutral and detached third party that can objectively look at the evidence in a perfect world, objectively look at the evidence and decide without any predisposed prejudices or anything else that could influence their decision. A judge, on the other hand, is an attorney, and they're going to understand the nuances and the idiosyncrasies of the law, and therefore they may decide that somebody's guilty simply just because certain aspects of the law have been met, whereas the jury wouldn't necessarily look at that. The jury would be looking at the facts, they'd be looking at the case, and they'd have to be all voting unanimously to find you guilty. So a judge in most cases is not the decider or trier of fact. In most cases, the judge is simply a referee. He's making sure that proper procedures are followed. He can make decisions and rulings as to how things will go for the trial or with a case. He will accept plea bargains. He can issue judicial orders and things of that nature, but typically it's to make sure that the proper procedures are followed. Again, only in those rare cases that the defendant actually wants the judge to be the decider of fact will the judge actually do that. And that's what we call a bench trial versus a jury trial. If the judge is the decider of fact, that's a bench trial. Again, it's another bad reason because for the judge to do that if you're the defendant is because, again, you're putting your destiny, I suppose, in the hands of one instead of the hands of multiple people. And the chances of bias, although it's not supposed to be there, but the chances of bias are much more pronounced with a single decider of fact instead of a multiple deciders of fact, i.e. a jury. So, you know, if you ever find yourself in criminal trouble, I would highly advise to request a jury trial and not a judge or bench trial, for sure. Now, with that being said, we need to talk about how judges are selected. There are a couple different ways that judges are selected, and it depends upon the level of court that they serve. For example, in small courts of limited jurisdiction, such as a city court, a lot of times the judges are appointed by the city council. And sometimes they do not even have to be an attorney. They can just be somebody that the city council says, you're going to be our city judge, and because we only handle very limited cases, then you can do this. And if it's a larger city, a lot of times the state law actually says, based on population, that judge must be an attorney. However, they can still be appointed by the city council. They're typically not elected at the city level. Now, they can be. In some places in the country, they can be elected, but most of the time they are appointed. And that's typically how we get judges into office. They are either elected or appointed. Now, there's a couple problems with either method here. If a judge is elected, then they do work at the behest of the voters, so to speak, and because of that, they can be voted out of office, just like you vote any other elected official out of office. But moreover, elected judges tend to be focused more on politics than they are necessarily their job, or they can get that way, because at some point they're going to have to spend some time running for re-election if that's what if they want to get re-elected. They're going to have to spend some time politicking, if you will. The other typical way that judges are put into office is via appointment, and if it's if it's a state court judge, an appeals court judge, or a state Supreme Court judge, some states actually just do it by popular election. And again, you can have a turnover of judges every single election cycle if that's the case. So, and some of them are if they're appointed by the governor typically, or by the city council or the county commission. And the interesting part about appointments is that who does the appointments? A politician. Who do politicians typically put into offices that they have the ability to control? Their friends, people that they know. So what the chances that you get somebody who is I guess similar in fashion to the appointing authority is very high. So some states actually have adopted a different way of judicial selection, and we call it the Missouri Plan, or it's been called the Merit Plan. And typically what that consists of is you'll have a panel of attorneys or other judges that will select a set of candidates to put forth to the governor of a state. The governor will choose one of those and appoint them into a judgeship. After a particular time or term in office, that judge comes up for what we call a retention election. And basically what it means is the people get to vote. There's typically not much politicking in this particular plan either. The voters get to vote whether or not this judge should be retained in office. Basically, if they get the majority, 50.1% of the vote, they're kept for another term. Then they come back up for a retention election again. If they don't get a majority vote, then it's the system starts all over, and the governor then requests a series of candidates to be sent forward to him or her, and then he or she will then appoint another person. They will serve a term, and then they will come up for a retention election again. So it kind of takes a little bit of the politics out of it, and it also takes some of the, I would say, friendship appointments out of it as well, because the governor has no idea who's going to be put forward to them from the panel that they will have to choose from. And it may be somebody they know, it may not be. It just depends on who the commission is that puts that judge forward. So depending upon the state and the type of judge it is, that's typically the way we get judges. You're either appointed, you're elected, or it's a hybridized version of both under the Missouri Plan. So make sure you read the Missouri Plan. I think it's on page hang on just a second and I'll tell you in your text. I think it's 172. Look on page 172. Now, it's also important to understand that from the federal side, federal judges are appointed by the president. And federal judges serve a lifetime appointment. We don't vote for federal judges. They are appointed by whoever the sitting president is if a federal judgeship is open, or a Supreme Court judgeship is open. they're appointed by the president, confirmed by the Senate, and once they go into office, they have the ability to stay there for the rest of their life, either until such time as they die, they retire, or they resign. Judges also have something called judicial immunity, and it is a total immunity, which means anything they do on the bench as part of their legal duties as a judge, they cannot be held liable for. Which means you can't sue a judge, you can't arrest a judge if he makes a bad decision, and their decisions are their decisions. Now, if they go out and they're breaking the law and they're doing something in their private life when they're not on the bench, at that point, that immunity does not apply. But judicial immunity does apply to judges while they're sitting on the bench, while they're carrying out their duties, that their word is the law, basically. And we have seen lots of judges in the past engage in what I would call erroneous interpretations of the Constitution, and then it takes another president or somebody or they just have to appoint a new person to that position. They put pressure on them to resign or retire or whatnot. But in many cases, we're stuck with those judges until such time as they decide to leave the bench. I mean, look at our U.S. Supreme Court. We've got some very old justices on the Supreme Court, some people that have been there for years that really are not making good decisions anymore. Some of them have never made good decisions. It was simply a political appointment based upon whoever the sitting president was, and they're erroneously interpreting the Constitution, in my opinion. And so we have to wait until they'd either die or retire or resign, so that hopefully a new judge, a new president will appoint a new Supreme Court justice that will actually interpret the Constitution the way it should be interpreted, which is the correct way. So just understand that from the federal side, judges are appointed for life, and they get to stay there. Make sure you read this whole chapter if you have questions. I mean, it's really not that long, 25 pages or so. If you have questions about this chapter, about judicial selection, about judicial duties, judicial immunity, make sure you reach out to me. Again, I will be getting in the discussions today and tomorrow, as well as getting some grading done in the online classes. So if you have any questions, make sure you reach out, and I'll see you next week. Bye-bye, guys.